Oh my.
Check.
There we go.
It's still. It is.
Testing 1, 2.
That's
Check,
lovely.
check.
It's lovely.
You
It
know,
cheers one up.
it does.
It cheers. Yes. I just know that.
Hello. I just want to say that there's a little bit of feedback. Can you hear that? Okay. The case on Maple Grove Road, if you're here for that, the case has been withdrawn for the sawmill operation on Maple Grove Road. Is that, okay, okay, thank you. Okay, well, it's 5:30 and I'd like to call this February 1st meeting of the Board of Zoning Appeals to order. Ms. Nestor Jelen, would you please call the roll?
Sure. And before I get started, would tech services go ahead and promote Skip Daly to be a panelist? Okay. While we're doing that, I will call the rest of the members. Margaret Clemens.
Here.
Pamela Davidson.
Here.
Guy Loftman.
Here,
Dee Owens.
Here.
Skip Daly.
There he is.
I'm here.
Great. Thank you. We have 5 members and a quorum.
Okay, and is there a motion to introduce the evidence?
I will make a motion to introduce the evidence.
A second? Okay,
I'd like to introduce the following items into the evidence. The Monroe County Comprehensive Land Use Plan as adopted and amended, the Monroe County Zoning Ordinance as adopted and amended, the Monroe County Subdivision Control Ordinance as adopted and amended, the Board of Zoning Appeals Rules of Procedure as adopted and amended, and the case is advertised and scheduled for a hearing on tonight's agenda.
is there a motion to approve?
motion to approve.
Okay, a second.
All right, there's been moved and seconded to approve the introduction of evidence. Skip Daly,
Yes.
Pamela Davidson,
Yes.
Guy Loftman,
Yes,
Dee Owens,
Yes.
Margaret Clemens.
Yes,
All right, motion carries 5-0.
okay, and this is another official announcement that the first case under old business has been withdrawn, and that concerns a property on Maple Grove Road, the conditional use for a sawmill, and that case has been withdrawn. If you're listening online or on the telephone, or if you're here in person, we will not be hearing that case tonight. So is there a motion to approve the agenda as amended?
So
I will
moved.
make- Oh, I'll second D.
Thank you, Pam.
Okay, it's been moved and seconded to approve the agenda with one amendment that the CDU 22-1 Maple Grove Gardens conditional use to chapter 813 for a sawmill at 6300 West Maple Grove Road has been withdrawn. A motion in favor is a motion to approve the amended agenda. Pamela Davidson,
Yes.
Guy Loftman,
yes,
Dee Owens,
Yes.
Margaret Clemens.
Yes,
Skip Daly.
Yes.
Okay, motion is approved 5-0.
I didn't see any minutes in the packet. Is that correct? Did I miss anything?
That's correct. I didn't-
Okay, so we move on to administrative business, and that has to do with the first item under administrative business. Board of Zoning Appeals Rules of Procedure, repeal and replace Article 6. Will you please refresh our memories on that, and then we'll have a motion and vote on that.
Sure. So this motion is to repeal and replace Article 7. So I've attached in the packet the current rules of procedure, which at the end of the last meeting, there was a motion to approve the change to make sure it's clear that the meeting starts at 5:30 PM each Wednesday of the month. So this is a subsequent amendment that we have in front of you tonight. So page 11 of the packet shows powers and duties, and this would completely replace the existing section about powers and duties. And if you all have had a chance to read through it, if you have any questions, we can answer those for you.
I did read this, but what was changed exactly?
Yeah, so it is a full replace D. I'll go ahead and pull up the old one
Mhm.
so that you can see them side by side if that is helpful. Or I'm happy to read through the sections that will be removed. So the old section is on the screen here. And a lot of these items that are subject to be removed are in the state statute, so we didn't feel that they needed to also be in the powers and duties. And this is something that needs to be added to the powers and duties. So it says, number 1, the board shall have general powers and duties set forth in state law and in Monroe County zoning ordinance, including without limitation, zoning ordinance chapters 808, 812, 813, and 821. So that will replace number 1 of the existing powers and duties A, B, and C. And then we've added number 2. With respect to its power to grant variances, the board shall determine whether a variance application is for a variance of use or for a variance from the development standards of the zoning ordinance. And then for the purposes of making such a determination, the board shall apply the following criteria. And we have A and B to determine use variance or development standards variance. And then number 3 is staying basically the same as it is as number 2. And then we have removed the sections 3 and 4.
Do members of the board have any questions for staff?
I appreciate your clarifying that you've referred it to state law without enumerating in the former paragraph 1. So thanks for explaining why that changed.
Are there any other questions? Let's see, I see, Mr. Daly?
You mentioned that number 3 is mostly the same. Is it possible that I could, you could give me 1 second to read here and then scroll up so I could see what is different?
Yes.
And I see that Mr. Chu Il Lee's hand is raised, but we're under administrative business and we don't take comments from the public normally under administrative business. So I don't know if there's a technical problem that needs addressing. But when we
Could you shift up now, please? Thanks.
Would I be right in summarizing that number 4 is also contained in the state code? Those standards, the previous
Yes.
number 4, if that's helpful, Skip.
No, I think I'm fine with it.
well, is
I
there a
appreciate
motion to approve?
I'm I've looked at this and I've read it, but why is it important in our rules that we have the authority to determine whether it is, I'm sorry, that's the,
Design
It's-
standard.
there we go. A use variance or development standard variance. When is this going to be? What's up here? I read it, but I don't quite know why we're making this change. It's maybe council could.
Good question, Guy. The state law states that you shall adopt rules that address this issue.
Well,
Whether, and
let's
then,
do it.
and the issue is going to be raised tonight, later on. And so it would be important to have a rule in place to guide you in making that decision. And I would note that the definitions in here are taken from case law in Indiana.
Okay, these definitions are great, but I'm not actually sure I'm grasping what it is that I'd be looking at, and especially if it's important tonight, I would if you could, what's the
Yes.
difference between, why is this an important distinction? What is the distinction?
Okay, good questions.
I've always wanted to have somebody say to me, that's a really stupid question. Not tonight. Yeah, not yet.
No, Guy, there are two different types of variances recognized in state law. One's called a use variance. And that is when you are asking permission of the Board of Zoning Appeals to conduct a land use that is not otherwise authorized by the zoning ordinance. So in effect, you are sort of amending the zoning ordinance by granting a use variance. And for that reason, because it's a legislative power, originally, the standards are very high for granting use variances. One of the criteria for a use variance is hardship, which has been defined to mean that if you do not grant the variance, hardship occurs, and hardship is the denial of all reasonable economic use of one's property. And that's a very hard standard. The use variance exists to avoid a taking. It's been described as a safety valve in the law to protect counties from a takings claim. So in other words, if you adopt a zoning ordinance and you apply it against a person's property and they are not able to do anything with their property, that would essentially be a regulatory taking. You can get around that by granting them a variance to do certain things with their property that would restore economic value to it. But it's a very high standard, and
Right, that's very helpful.
yeah, denying all reasonable use has been interpreted, or it has not been found if there are other uses allowed in the zoning ordinance table, if you can use it for recreational purposes or other uses like that. So it's a very high standard to meet. The design standards variances are just that, or development standards is what they're called in the statute. We've always called them design standards. They relate to the design of land improvements. So the location, setbacks, the height of buildings, lot coverage, slope restrictions, things like that are design standards variances.
That was a good answer.
Okay.
Are you saying on the use variance, the only standard the state recognizes is economic?
No.
Because you kept saying that in terms of hardship.
That was,
It's economic and no other kind of hardship?
no, yes, economic hardship.
Wow.
There's other criteria involved in
Yeah.
that use variance as well, but that's the one that's the most difficult for most people to demonstrate is hardship.
Thank you.
Thank you. I move that we adopt the amended rules as proposed by staff.
I'll second that.
Okay,
Okay, it's been moved and seconded to repeal and replace Article 7, powers and duties as shown in the packet. A motion in favor is a motion to approve the repeal and replace of this section of the BZA Rules of Procedure. Guy Loftman,
Yes.
Dee Owens,
Yes,
Margaret Clemens.
yes,
Skip Daly,
Yes,
Pamela Davidson.
Yes.
Motion carries 5-0.
okay, great. Thank you. Thank you for cleaning up our rules and procedures and helping us move along. Now we're on to the second item under administrative business, and that is the election of the chair and vice chair.
I would move to nominate Margaret Clements as our chair.
second,
Thank you, thank you. Thank you for your confidence in me. I appreciate it.
I can go ahead and call the roll on that first one, and we'll do the vice chair if that's okay.
Sure.
The next, yeah, should we do it one at a time or you want both?
I'll do one at a time.
What, well,
Okay.
we've got one, let's do it.
Okay, so it's been moved that Margaret Clemens be served as the chair of the BZA. A motion in favor is a motion to approve Margaret as the chair. Dee Owens,
yes,
Pamela Davidson,
Oh, yes.
Margaret Clemens,
I humbly accept. Thank you.
Skip Daly,
Absolutely, yes.
and Guy Loftman.
Yes.
Okay, Margaret is the chair, 5-0.
Thank you.
And I would nominate, yes, congratulations, well earned. I would nominate if he consents. I haven't had the opportunity to ask him before the meeting. Skip Daly for vice president.
I'll second that.
And if he consents.
Oh, it didn't hurt me last year. Why not?
Okay, I'll take that as a yes. So Skip has been moved and seconded as vice chair. A vote in favor is a vote to approve Skip as the vice chair. Pamela Davidson,
Yes.
Margaret Clemens,
Yes.
Skip Daly,
Sure.
Guy Loftman,
Yes.
Dee Owens.
Yes, why not?
Okay, motion is approved 5-0.
Okay, we have no old business. As I stated before, the case concerning Maple Grove's Gardens Sawmill has been withdrawn by the petitioner. And so if anybody is tuned in online or on their telephone or is here in the room for that case, we will not be hearing that tonight. Instead, we move on to new business, and this concerns item number 3 on the agenda, because items number 1 and 2 have also been withdrawn under new business. And item number 3 is VAR 22-53, Joe Huff Design Standards Variance to Environmental Constraints Overlay, Area 1 from Chapter 825, concerning 46.2 plus or minus acre parcel in Clear Creek Township, Section 7 and 12 at South Shady Side Drive. And this is zoned agricultural rural reserve, and it's in an Eco 1 constraints overlay. And so what we'll do is ask staff to give us a preview of this, and then the petitioner or the petitioner's representative will have 15 minutes to discuss with us their point of view. And then we'll hear from the public who is opposed to the petition and the public who is in favor of the petition. And each person will have 3 minutes to speak. And then the petitioner will have a 5-minute rebuttal period. And then we'll have further discussion and questions for the petitioner and staff. So staff, if you would be so kind as to go over this with us.
And Margaret, just to clarify, you said 3 minutes for supporters, remonstrators, 5 minutes for the petitioner's rebuttal. Was there an initial time limit for the petitioner's first
It's
presentation?
15 minutes.
15, thank you.
Yeah.
Okay.
15 minutes. Thank you.
All right,
Okay,
thank you, Margaret.
Thank you, Ms.
I
Behrman.
first wanted to say that I'm Tammy Bierman. I am the Assistant Director of the Monroe County Planning Department. And I will be kind of giving you a presentation which will kind of represent the reading of the initial staff report.
Okay, thank you.
So staff would like to go through the entire presentation, but first we would like to point out that staff interprets this petition as a design standards variance for Eco 1 slope standards. Here you will see the approval requirements for a design standards variance. They're continued here on the second slide, which also includes practical difficulties. And I have the definition for practical difficulties here. This is the criteria that has been consistent with how staff has administered variances to the Eco chapter. However, the petitioner's 210-page introduction of evidence found in Exhibit 14 of the staff packet and staff report includes a claim that this request should be treated as a use variance, which has a different set of standards of approval, which are listed here. Staff has put together findings for both types of variances and is prepared to answer claims to, either one of these. In terms of either a design standards variance or a use variance, staff did not see findings to support either practical difficulties in the request as a design standards variance or as an unnecessary hardship in the request for a use variance. So basically, after this presentation, of the entire report, you will be making first a vote to decide if this should be a use variance or a design standards variance. And then second, you will then need to decide on the merits of the case and based on the findings, if you want to approve or deny the request. So this is the request. This variance request is considered after the fact and is for a recently constructed, approximately 350-foot long by 20-foot wide private drive on the petition site that is intended to be used to access multiple principal structures. If the variance is granted, it would apply only to the private drive and allow the petitioner to keep the new private drive as is. If the variance is denied, a grading permit application would be required along with a remediation plan for removing the private drive and revegetating the area. I wanted to go over a timeline. This is not necessarily in the staff packet, but it may help kind of explain the story here. So in September of 2016, the petitioner contacted planning staff, whereas then we had informed them of the eco restrictions of this property. Then that following February in 2017, the petitioner purchased the property and began logging it soon thereafter. In May of 16th of 2019, Monroe County Circuit Court case was filed. And there's the case number there. As a result of that, a memorandum of agreement was issued. And one of the points in that was that the petitioner needed to seek all necessary permits. In April 9th of 2021, staff met with and informed the petitioner of variance requirements for a new proposed driveway at that time because of the slope restrictions in this eco area. Sometime between the winter and spring of 2022, a new drive was constructed without permits or variances. Staff was basically alerted to that because we had February aerial pictometry for 2022 was released. We were able to view that data and those aerials and see that. Shortly thereafter, staff was allowed to enter the property and do an inspection. At that time, the new private drive was complete. April of 2022, the next day after that, site plan SIT-22-15 was filed by the petitioner for a main vacation home. Then in November 5th of 2022, the Monroe County Circuit Court filed an order. And the order basically told the petitioner that he was required to get variances for this new private drive. And then a month later, the variance petition was filed. And here we are at this presentation. So we're going to go through some photos and some maps, kind of orientate you to this area. This is what the property area looked like on March 25th, 2017 from our aerial photography. Very wooded. By February 19th, 2022, we see that there is an existing drive which kind of dips towards the lower end of the screen, and then a new private drive which was being constructed on, and you can kind of see the gravel that's being added and the grade work that's being performed. The staff site visit April 18th, 2022 allowed us to kind of view both of these drives and inspect them. You can see here the upper one is the existing private drive and the lower one is the new private drive. And it's the new segment, that lower drive, that is what we are going to be discussing most this evening. This petition site is located on Lake Monroe Reservoir, and it is mostly in Clear Creek, sections 12 and 7. We pull this image up here. We have the Shores subdivision. It comes off of Shady Side Drive, which is also how this petition site accesses their property, or the petitioner accesses their property. I'm pointing out the Chumley Peninsula. It is also owned by the petitioner, is separate parcels, but we will also mention that at some point during the petition. And then also the way that the hills are sloped where this road segment is, just because it doesn't directly slope towards the lake, it does slope towards these riparian areas, which you can kind of see in these light blue areas. These are perennial streams. Any erosion or runoff from there does have that ability to enter into those streams and then enter into Lake Monroe Reservoir. So in this part of the county, we restrict slopes by 12%. And this is a map that represents all of the restricted slopes for this area. Anything not in red, you would be able to develop on. This is again here the site that we'll be talking about. And this is an up close view of the aerials from 2021. Again, this segment, this is the existing drive. It was used for hauling timber, bringing in large, work, heavy machinery, grading, gravel was hauled on this road since sometime in 2017. So the environmental constraints overlay is a chapter within the Monroe County zoning ordinance, and 825-4. These are the requirements that are set forth in Area 1, where we restrict those 12% slopes. It's the items in bold under this section that the petitioner is not able to meet for this after the fact private drive, and therefore the petitioner is seeking a variance from the Eco 1 provisions. So the two parts that they cannot meet are, one, the maximum land slope upon which any land disturbance involved in construction of buildings, driveways, roads, parking lots, and utilities can occur shall be 12%. The percent slope shall be measured as a 6-foot fall in any 50-foot distance. The design should be suited to the lot to minimize the amount of cut and fill. And then second, there shall be no disturbance of natural vegetation beyond the 12% slope. And just as a reminder, this is Monroe County, and Lake Monroe is depicted here in blue. We have the different environmental constraints overlay that kind of buffer our lake to help protect and prevent sedimentation of Lake Monroe. The red arrow points to the petitioner's site. And just as a reminder, in 825-1, the purpose of the ECO is to protect and enhance public health, safety, and welfare, preserving and enhancing the water quality for residential, industrial, and public use. Also, like preventing pollution, erosion, siltation, and the loss of topsoil. So there's a reason why we have this environmental constraints overlay in place. Lake Monroe is a reservoir, and those do have a tendency to silt in and sediment in over time. We'd like to extend that lifetime of that water source as long as we can. And included in the staff packet are some maps that depict the steep slopes, and it's a severe slope map. So here we're looking at slopes from 0 to 55. The Shady Side Drive, cul-de-sac there at the top, and you'll notice that the petitioner's private drive comes from that cul-de-sac, goes through a series of different steep sloped areas, has this wide open spot here, more steep sloped areas, and then finally we're going to be mostly concentrating on this spot here where they built this new private drive. And this is an up close view of that. The new private drive is not on here, but it kind of runs through these 16 to 21% slopes. So this is a map kind of showing the surrounding area. The steep slopes on the petitioner's site do not create or constitute a relatively unique development problem in the Lake Monroe area. These are typical of this area. So it's not unique just to this petition site. You'll see here in this next photo, the Chumley Peninsula that I pointed out earlier is here, and this belongs to the petitioner. The site is just off slide here where we're talking about tonight, but around Lake Monroe, we've got these steep slopes, and it's just the nature of the area. Here's a view of the petition sign off of South Shady Side Drive, cul-de-sac. This is the petitioner's private drive where it begins to enter the property. Just to note that the BZA rules of procedure for legal notice were followed by both staff and the petitioner. Photo 3 of the staff packet viewing, is a view facing north from the new private drive. So the drive was behind that staff person's back. You can see the vegetation that has been disturbed in this area. This is a view of a comparison of the existing private drive here on the left and the new private drive on the right, constructed without permits or a variance from the eco area. This is a view facing southwest. This is a little typo in the packet, to the side of where the new private drive was constructed. And in photo 6, staff measured the slope on the property from the top of the new drive using a 6-foot pole, which is depicted there in pink, and a string across 50 feet, which is the green line. If the slope were less than 12%, the string would show as being flat or lower than the person to the left. Instead, it shows the string is higher and on the left side indicating slope is greater than 12%. The percent slope shall be measured at a 6-foot fall in any 50-foot distance. Just wait a sec. So this is myself that's on the right-hand side of the picture. I'm 5.5 foot tall with shoes on. If I'm standing with my arms above my head, that is 6 foot. It's pretty easy to work with this kind of measurement in the field to depict those 12% slopes. So here's what it should have looked like. You should have had that green horizontal line, 50-foot long distance, and a 6-foot fall, and that would give you your 12% slope. But what we were seeing could be maybe more estimated around 18-20% slopes. And again, this is another picture depicting that from a different angle, with Jackie there on the left and myself on the right, showing that this green line should really be more horizontal in nature. So there's another view showing the disturbance area from the construction of the new private drive. Staff is facing southwest. And a view of the new private drive facing east. That's that bottom left-hand side. And a view facing east looking at the slope greater than 12%, standing on the new private drive. Just to note that the existing private drive connecting to the new private drive is just as steep. So focusing here in this area where the new drive kind of dips down and you can't quite see it, I will show a slide next that shows that this area here is basically just as steep as on the left-hand side of the screen. So these are contours from site plan from 2021. And within this 192-foot distance, we can count 17 contour lines, essentially a 17-foot drop within that area. And again, over here, and this is the area where the new private drive has gone, we see these sloped areas here as well. We do not see any kind of changes to this other steep part of the drive. So you may hear claims later on regarding other steep parts of the drive. And we're just depicting that we have equal areas within relative close areas of them being just as steep. The highway department made some comments. I will just read some of those directly. And I will want to say that there's a correction in the staff packet on page 62. I think we had said that nearest right-of-way was 1.3 miles away from the petitioner's private drive entrance. And actually it's 0.4. Shady Side Drive does partially, it is both public and private drive. So in relation to Exhibit 14, which the petitioner submitted, the Monroe County Highway Engineer has confirmed that Chapter 755 would not apply to private drives. The Monroe County Chapter 755 is largely based on NDOT or AASHTO standards for public roadways. The nearest right-of-way line to this property is 0.4 miles away. The petition site gains access from Shady Side Drive, a private road about 0.4 miles that connects to Shields Ridge Road. the highway engineer's perspective, the area that would be regulated under chapter 755 would be 25 feet from the right of way, which would be more than like that 0.4 miles north of this site. According to the highway engineer, none of the private drives on the petitioner's property appear to meet the grade, vertical, or horizontal geometry or the site distance for NDOT or Monroe County 755 requirements. Though not a requirement to meet these standards, it is also important to reference that the new private drive likely does not meet the standards either, with no evidence from the petitioner that it would meet these standards. So again, this is the drive that kind of we're discussing. And another photo facing west. And this is a view of that new private drive facing west. View of the property north from the new private drive. And then this is a view of the two private drives, the new one on the left facing east. The county car has accessed this existing private drive for the site visit without issue. We even had some of the highway department's trucks out there as well. We were all able to navigate it just fine. Due to the clearing near this private drive and towards the lake with the stumps being grinded, it is clear that this area is intended for residential use. So photo from 2020, heavy equipment located on the Chumley Peninsula that utilized that existing main drive for access. So see the timber and the different equipment that have utilized that existing private drive. And again, another image of that heavy equipment located on the Chumley Peninsula from April 18th of 2020, prior to the new private drive construction. So we're going to be reviewing some site plans next. Staff has seen several iterations of site plans. This is the most recent one, the one that was basically submitted with the variance this evening. So June 20th, 2022 is when these were submitted to staff. We have kind of superimposed a few things on here and highlighted a few items to point out that the black is the new private drive that was built without permits. The red is the existing drive. And then we really want to point out that the blue highlighted here represents the 12% slopes. And the slopes also encompass this new private drive that was built. Here we have plans from April 15th of 2022, where you can kind of see as a whole of all the different site developments that the petitioner was intending at this date and time. Again, we'll focus in on this area here where the private drive was not, it's starting to be depicted here is the private drive. We've got an overlap of their house design, and then the new drive is here just north of it. And here it is highlighted so that you can see that the petitioner's footprint for the development that they desire has extended into the existing drive, which is why most likely they were prompted to build this new drive. Planning did meet with the petitioner to discuss variances to install this drive at one point. And so here's a comparison. And one thing that you may want to focus on are those 12% slopes. So in April, the slopes were depicted, not including the private drive that was new. And in June of 2022, about 2 months later, they redesigned slopes here and change it. So we're just making sure that you can see that comparison between these two site plans that were submitted by the same engineer. This is a floor plan submitted in February of 2022. Includes pool, patios, covered porches, a detached garage, and you can see this lines here are the slopes, the 12% slope delineation. And you can also see the ghost image of the existing drive that cuts through their design. This is the second floor. Staff is unsure if there's actually a basement here or not. That hasn't been confirmed yet. Now we're going to go back in time a little bit more. These are the 2021 plans from August 30th. This is showing a home footprint not requiring a new private drive. So in these plans, you'll see this area here, which is approximately 8,750 square feet. And this is an area that does not, extend into the 12% slopes, and the existing drive is being utilized here. So the prior proposal that you just saw was at 8,750 square feet of buildable area, essentially, slopes that were less than 12%. The current proposal that staff measured using the most recent plans from June 20th, 2022 are 11,200 square feet for that pool, patio, porches, garage, and encroaches into that existing drive's footprint. These are plans that are dated March 3rd of 2021. So we're going farther back in time. And at this point, there really was no plans to even include development here on this part. So plans had been evolving, it seems like, over these last few years. So the memorandum of agreement that was as a result of the Monroe County Circuit Court settlement agreement stated in number 7 that the Huffs agree that prior to beginning any residential, commercial, and non-agricultural construction, the Huffs will seek all necessary permits. Here we just saw evidence that they created a new existing drive. Their site plans are showing that their main vacation home would be encroaching into the existing drive, thus pushing them to need that new drive. This was a document that was issued in October of 2020. Then about 2 years later, November 5th, 2022, an order was issued by Judge Holly Harvey. This is on page 101 to 105 of the staff packet. It's an order on motion to enforce settlement agreement. And within that order basically states that the planning director does not have the authority to issue variances under the Monroe County zoning ordinance. The Huffs must proceed to obtain variances for uses not currently allowed under the current zoning of the property through variance processes set out in the ordinance. And then number 3, the Huffs violated the terms of condition 7 by building or modifying the road within the property, which used for timber and logging without the necessary permits. The Huffs are required to either rebuild the road or obtain a variance to bring the road in compliance with applicable statutes. So the variance was filed December 6, 2022. This is the request letter from the petitioner. And at this point, it's really down to the members, the BZA members, needing to decide if this is going to be a use variance or a design standards variance. And with that, we will briefly review that Article 7 that was just adopted under the rules of procedure. And this is what gives you those powers to be able to decide if you want to do this as a use variance or design standards variance. I will add that staff feels that the use of the new private drive is not in question. The design and the location of the new private drive is in question due to the existence of the steep slopes greater than 12% and the location being an Eco 1. The existing private drive allows the owner to apply for any of the following 53 permitted uses on the property. The table is in staff packet of all the uses that are available. These are agricultural uses, residential, public and semi-public, business and personal services, for example, bed and breakfast, retail and wholesale trade, and amusement and recreation. All of these uses would be able to be permitted using that existing drive the new drive would not be required to do those. So, staff is, we see that it is a design standards variance. That's how we've treated other similar cases in the past. But I'll go ahead and let you all decide between A is the use variance and B would be the design standards variance. And we do have findings to back up the merits of either of those, either way, which you're, wanting to go.
Okay.
Sorry, thank you. Before you address that issue, you should allow the petitioner, of course, to weigh in on the use variance, design standards variance issue.
Yes, so we will move now to hear from the petitioner. I assume that Mr. Chuil Lee is here on behalf of the Huffs. And it's my understanding that you're an attorney, so you do not need to be sworn in. And so if technical services can unmute Mr. Chuil Lee. Mr. Lee, if you would go ahead, you have 15 minutes to discuss your point of view with us.
Well, prior to beginning that 15 minutes, I want to make sure that I'm clear what Mr. Schilling had just indicated. My understanding was that he thought that I should address this whole issue of, is it a use or is it a design variance prior to moving forward to the defense? I don't want to put words in your mouth, Dave, but that's what I believe that I had heard. So I just guess I need some clarification from this board as to whether or not you would like for me to address our arguments in total or just solely the issue of whether this is a use or a design variance at this time.
Well, Mr. Chuil Lee, I'm the president of the board. My name is Margaret Clements. And if you would like 15 minutes to talk about whether or not this should be a use or a design standards variance, we can discuss that issue separately and then move on to the other case, that the 53A and then the 53B. So it's pretty much up to you. If you would like to take 15 minutes to discuss with us why you think it should be a use rather than a design standards variance, we'd like to hear from you.
Great, and I will take that opportunity. Thank you, Madam President. The issue here that we talk about the use and the design variance comes down to a critical starting point. First of all, it is our contention that under Section 1103, the county cannot institute any kind of regulation which interferes with a landowner's use of his property, his or her property, if it is agricultural in nature. And logging falls into that. And so what we are talking about is approximately 350-foot section of road. The affidavits that are in front of you from Mr. Smalling and Mr. Freeman indicate and show that that new, what we'll refer to as the new road, that 350 feet, was put in there because they were having issues with the agricultural uses on this property. They had attempted to continue to use the higher sloped road, the existing road, the old road, and they were losing equipment. They would have to drag equipment up using bulldozers. The cost of that and the damage to their machinery was rising. The erosion essentially that was created upon that higher road because of the manner in which it had to be utilized in order to get their trucks up and down was much faster than in normal usage. And so it is Mr. Freeman who had put that new area in, that 350 feet, for the agricultural purposes. Now, this new rule that the board enacted today, after Mr. Huff and Mrs. Huff filed their variance, after they raised their issue that said this is a use variance, that new rule is trying to say, well, it's a use when you talk about the entirety of the property, but that's not what the Monroe County zoning ordinances say when you talk about use. Use is defined several times in your definitions. Use any purpose for which a structure or a tract of land may be designated. We have gone through this. I don't think there would be any disagreement from the planning department that a road is included in the definition of a structure. That's been part of their arguments throughout. Use is permitted. Any use of a land, building, or structure which use is permitted in the zoning district. Again, that structure is the road. At this time, we are talking about not a design variance on this, because for the agricultural purposes, they are allowed to place that in there without any permits, without any licenses. When it comes to the issue of simply the use of that for the residential purposes that are coming up on this property, that is why this is a use issue. And it has to be noted because Ms. Bierman referred to and has as part of her packet Exhibit 13, which is Judge Holly Harvey's order, and she placed that in front of you for consideration. She made several comments about it, saying, see, this is why that this variance is here. The problem with that is that the appellate court has already ruled against the county and their motion to dismiss that appeal. They have accepted the appeal of Judge Harvey's order, and therefore that order carries no weight of law. And so this board should not be considering that order or anything in that order or any argument based upon that order, because it is not a standing and valid order as of today's date, once the appellate court denied the county's motion. And that was on January 13th of this year. So when we talk about this 350 feet, yes, it is a use variance because the Huffs are wanting to utilize that in the residential manner, which technically, and we would agree, they would not be able to utilize prior to a variance being granted at this point. But that does not and should not, although I'm sure that the county would disagree, impact their use of that for logging purposes. Thank you.
Thank you, Mr. Chua Lee. And now, if you could just stay by the microphone, members of the Board of Zoning Appeals may have questions for you and or staff. So are there members of the Board of Zoning Appeals who have questions for the petitioner or for staff?
I have
Yes, Mr. Law.
I have one, and I'm not sure which of these issues it goes to, but anyway. I just want to know, is the logging been substantially completed?
Mr. Chua Lee, has the,
No, I mean, that's kind of a very broad term. I would say there is much more logging that still needs to be performed at that property to conform with the best management practices that was laid out through IDEM that Mr. Huff had done prior to starting the logging process.
Are there any currently pending uncompleted contracts with any loggers?
Yes,
Or is all-
he is still working with the logging companies, that are out there.
Okay, are there any signed contracts that haven't been completed yet?
Yeah, I believe, and again, this is my understanding, is that the loggers out there have that best management practices guideline, and they are logging the property according to that. And they've got the contract for it, and they continue to work on that. You know, part of this was escalated a little bit and caused to be advanced in a more quick fashion when the storm came through on that lake and it downed hundreds of trees on the Huff property. And so they had to come through and clear out those trees, which is around the time in which that necessitated this new 350-foot area.
Thank you.
thank you, Mr. Daly.
My question is for Mr. Schilling. Prior to the board adopting the new rules that we adopted tonight, did we have the authority to determine the use versus design?
Yes.
Thank you.
Thank you. Ms. Owens?
Thank you very much. I'd like to ask the attorney, Mr. Lee, if he was the attorney for the Huffs on April the 9th of 2021.
Yes, I was.
Okay, and my follow-up to that is that you met with staff and they said in order to build the second driveway, there had to be a variance to be approved, yet it was built anyway. Is that correct?
It was, well, the staff did indicate that. It was built by the loggers and Mr. Freeman when they made the determination that they needed a new roadway in there.
Oh, so
Which-
the Huffs didn't approve having a road built on their property?
Well, no, when the loggers and the agricultural utilizers of that property, Mr. Freeman and the loggers came through and said, we need to get a better access through here because of safety reasons, because of upkeep reasons. Yeah, the Huffs approved that because under 1103, for agricultural purposes, that is allowed.
So they ignored what staff said and did what they wanted.
No, I disagree with that characterization, Member Owens. It is if and when the Huffs were coming for the residential purposes, which is consistent with the agreement that was shown before, when they were going to come for the residential uses, they would come back. But when it comes to logging, when it comes to the agricultural purposes, they did not have to do that. If you go back and look at that order or the agreement in Article 7 that Ms. Bierman pointed out, it says for non-agricultural purposes is when the Huffs would have to come and get those permits. This and implementation of this road was for agricultural purposes.
Okay, Mr. Daly has another question.
My question is for the presenting attorney. Sir, if I'm understanding this correctly, your presentation is suggesting that the road that has been characterized as the new road by staff was built and used for the purpose of agriculture, and therefore you did not require the permit. And now that the road is there, you're building it into the design. Is that correct?
Yes, we're asking for the variance for that. Now, I will say, I think this is important, and I think, Mr. Daly, you bring up a very important point. The presentation regarding the April 2022 plan where the house was shown over the old road, the February 22 plan, those plans were created after those initial plans that were filed back in March of 2021 were stopped by the Plan Commission. There was no answer to that, or August of 2021. Their plan was stopped. This new road came in. That old one was stopped. Okay, well, let's put in a new plan because it wasn't going anywhere. And that stop is a critical thing because it wasn't a denial. It wasn't a rejection by the Plan Commission or the Planning Department. It was a stopped application. So we couldn't bring it to the BZA for consideration on appeal. Here, we had a layout which would have worked, which does work with the old road there. And we will make a commitment tonight that even if this variance is granted for the use of that new road for residential purposes, we'll go back to the August 30th, 2021 plan that was submitted that was stopped by the Planning Department and put it in that old section that has plenty of space for it. But when that wasn't going anywhere, we tried something else to see if it would get through the Planning Department.
Sir, I have another question for you.
Yep.
What was the date that this road, this new road, was installed?
I don't have that exact date. I don't think any of the applicants said the exact date and when it came through. I know Mr. Borgman is here. I don't know if he is aware of the exact date or not. But-
And I ask because the chronology is important to me.
I would say the chronology is that new road was implemented sometime between August of 2021, when their initial plan was put in, and February of 2022, when they first put in a new design on the site plan.
Okay, and just let the record reflect that staff has put up an aerial photo that's dated February 19th, 2022 of that second road, the new road being constructed. So yes, Ms. Davidson.
I have a question as well about the agricultural claim. You said that a storm came down, removed a lot of the trees, the loggers had to come in and clear up the trees. You said that the logging practices are best practices today, but when we look at the photography of this site, it looks completely bare. It looks denuded. It looks like there could be no more lumber harvesting or agricultural use of that area. Are we wrong about that?
Yes. The Huffs own over approximately 350 acres of property there. And if you look at that entire property, there are still several hundreds of thousands, I would say, of trees still located on that property. And under the best management practices, they went after the invasive species first that are located at the property. And then they went after some of the other trees that would not allow the good, healthy, natural trees to grow and have their canopy. There are still a large number of trees that can be harvested from this property, even under the best management practices that's set forth by IDEM.
And will all that harvesting be via one of these two roads, the new and the old road? Is that the only way to access all these trees to be harvested?
On this peninsula, yes, unless you want another road that's put in. And the affidavits of the loggers and the agricultural workers out there have indicated they're not going to use that old road because of both the cost concerns and the safety concerns when you look at that. And those go more towards the analysis for the variance itself. And so I don't want to overreach what we're discussing at this point.
Thank you.
Okay, well, Mr. Loftman.
So they put that road in, and they were putting it in on February 19th, 2022. And no, I don't have a question. I'm just processing this.
Okay, well, I will move to members of the public. And again, this particular discussion has to do with whether we will be invoking a use or a design standards variance in on this case. And so those people who are in favor of invoking a design standards variance, would you please raise your hand and in order to be recognized? And tell us why you think that a design standards variance would be more appropriate than a use standards variance. So if you would, either if you're here in the room, come to the podium. If you're online, please raise your virtual hand, or if you're calling in by telephone, please press *9 on your telephone in order to be recognized. Okay, I see there is a telephone number I think that the staff has unmuted you. And would you please state your name? I think you took your hand down. If you are interested to speak, please raise your hand. Okay, so there's no one who is in favor of speaking on this issue. Oh, again, the telephone number 239 has their hand raised, the area code 239. If you would please unmute yourself. If you're on a telephone, press *6.
I think I'm hello.
Oh, would you please state your name?
My name is Michael Kane.
And Michael Kane, Mr. Kane, would you please raise your right hand? And do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And we also would like to know where you live. Where do you reside?
I have a house on Shadyside Drive. I've had a house there for 25 years.
Okay, well,
I
Mr.
reside in Florida. I'm only there part of the year.
Okay, well, you have 3 minutes to speak, and then after you're finished speaking, we have yet another aspect of this case to hear. So you may be interested to remain. So we are anxious to hear from you.
I have an opinion about whether this is an agricultural change. I believe that the logging is substantially completed on that land. You just have to look at the aerial photos. I've monitored this logging for 4 or 5 years now because I've been in a lawsuit with the Huffs over it, because I'm an owner of a property in the shores and they're using my easement to transport the logs. That's the nature of the lawsuit. The bulk of the logging is done. It was very intense, and by 2021, it was pretty much over. I see that as a red herring. I think this is all about the design. That's what this road was for. I was on that property as in a court-ordered inspection prior to 21 when they built this new section of road, and it was a mess, but they were logging. I mean, that's why I think it is a design use. And I would correct the attorney. I don't think they've been following a plan from IDEM, the Department of Environmental Manager. I think they've been following a plan from the DNR. It's a forest stewardship plan of best practices, and it mentions restrictions from the county on property adjacent to the lake. But primarily that plan is about maximizing timber harvest for profit. It's not about protecting our lake. And I think that's what people are concerned about. Thank you.
Thank you, Mr. Kane. Is there any other member of the public who is, I see a hand raised by Patricia Dennison. If Tech Services could unmute Patricia Dennison. And when you're unmuted, would you please state your name and raise your right hand? And do you swear to tell the truth, the whole truth, and nothing but the truth?
Absolutely.
So you have 3 minutes. Your name is Patricia Dennison?
That's correct.
And where do you live? Where do you reside?
I live in Monroe County.
Okay, great. Well, we would like to hear your thoughts on this issue.
Thank you very much, commissioners and staff, for the opportunity. I will read a prepared statement. As a citizen of this county, we should expect all developers, especially ones so seasoned in the pursuit of land development, to know that wherever you are in this county or the country, including this one, that all people are required to respect and abide by the rules that apply to all. From the beginning of any development, especially in a watershed, this is all spelled out very clearly for public, private attorneys, step by step. Number one, you need site plans. Number two, you need permit applications. Number three, inspections every 2 weeks. And I'll stop at number 4. You need county authorization. To literally ignore all and more of the above, and then request a mea culpa would set a precedent for further abuses of the very purpose of the environmental constraints that are in place to preserve and protect, pardon me, the public health, safety, and welfare, as stated in Chapter 825 of a water source within a limited lifespan for a growing community. And this isn't a lake. This has an expiration date. And these laws and regulations are in place to enhance its lifespan. So I would say an absolute no to any variances, use or design of this property or any other property around Lake Monroe that threatens those things that I've mentioned. Thank you so much.
Thank you, Ms. Dennison. Are there other members of the public who would like to speak? Yes, sir. Would you please come to the podium and sign in? There's a sign-in sheet here. Sir, would you please state your name?
Yes, Jeffrey Ruthenberg.
Could you say that one more time?
Jeffrey Ruthenberg.
Ruthenberg. And would you please raise your right hand, and do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes,
Thank you, Mr. Ruthenberg. And would you state also what county you reside in?
I live in Monroe County in the watershed.
Oh, great. Well, you have 3 minutes to talk with us about your point of view.
Okay, first, I'd like to thank you all because you have a thankless job, a difficult job.
Thank you.
And my main concerns are the quality of the lake. I think we all tasted and smelled the water this past year. I think we need to do everything we can to preserve the quality of the lake. I would say also on this property that the plaintiff is, or the petitioner has consistently gone against rules and orders. And my fear is that he's going to do whatever he wants to do, regardless of the law. So I speak against a variance, whether it's use or design.
Okay, thank you so much for sharing your thoughts with us. Is there any other member of the public who would like to weigh in on this issue of use or design variance? If so, please come to the podium, raise your hand, a virtual hand on Zoom, or press *9 on the telephone. And that also goes for if you would like to speak either way now, if you would like to speak in opposition of a design use variance instead of a design variance instead of a use variance, please raise your hand. Please let us know you'd like to share your thoughts with us. Press *9 on the telephone. And if we see none, we come back to Mr. Chui Lee for a 5-minute rebuttal. Oh, yes.
I have another question. if I could. A number of the comments have been about the water quality, which is a very potent local issue, no question. Neither one of these roads, the existing or the new, really impact the water quality as far as we know. I mean, it's one's closer to the lake slightly, one's farther away. The slope such is that there's going to be some kind of erosion or drainage down from that, no matter what, just because of the height of it and how far down the lake is. But when we're looking at these choices that we have, we shouldn't be considering water quality because that's not the issue before us. And there's no evidence that either road has an impact plus or minus about that. Am I right or wrong?
Could I just say one thing before you answer?
Yes.
So this is in an area with an ecological constraint overlay. And the reason it has the ecological constraint overlay is to protect the water quality in our communities, drinking water and other uses for the water. That's why there are prohibitions from building on slopes that are greater than 12% in that eco constraint overlay area. That being said, I'd like to turn to staff and maybe answer Ms. Davidson's question more.
Well, number one, you're dealing with the issue of use variance versus design standards or development standards variance at this time. To grant a use variance, you would need to show that granting the variance will allow a use that is not otherwise permitted on that property. So the question would be, what uses are permitted on that property? Would granting this variance allow some other use that is not permitted? That's the use variance question. As far as whether there has been erosion or anything caused by the new road, that wasn't an issue that the staff addressed because it doesn't relate to this design standards. They don't need to go beyond what's in the ordinance. So.
Thank you.
Okay, thank you. And Mr. Daly?
Thank you. And I'm going to address a question toward Mr. Schilling. So is it true from a legal standpoint that the petitioner had the right to log the property? Is that yes or no? Is that true?
The petitioner had the right to log the property and still has the right to log the property.
Okay. And now, would a permit be required to put that road in order to log that property?
It depends on where it would be located on the property. And
let's assume we know where it is located on the property. Let's assume it's the actual road in question.
Yeah, it would require site plan approval under our ordinance.
Okay, so even if this were an agricultural use, prior to putting that road in, the petitioner still would have required a permit or permission of some sort from the county. Is that correct?
Yes, our ordinance requires site plan approval for agricultural uses. And we've heard about section 1103 tonight. And that section states that we can't apply the zoning ordinance in a manner that would prohibit the complete alienation of timber resources. That would mean that you can't take any trees off the property and prohibit you from taking trees off the property and selling them. And the county has not done that. And site plan approval, in my mind, would not cause that to happen.
So is it fair to say that you disagree with the petitioner's original statement that they did not need permission to put that road in, and I'm paraphrasing his words.
Yeah, you do not need an improvement location permit to put in a road that is used exclusively for agricultural purposes, but you still have to comply with the design standards for the road. But that, I guess, Skip, the issue right now is the use versus the design standards.
Okay.
Okay, and I see that Mr. Kane's hand is raised, but our rules don't permit us to go back to you at this time. I'm sorry, Mr. Kane. Our rules require that we move on to Mr. Chu Il Lee for his 5.
I just want to make a comment from my perspective. If we're looking at, I always look at Lake Monroe. And if this second road putting in a second road increases erosion and sedimentation and everything else. One road putting in a new road creates erosion and sedimentation problems that wouldn't be there, in my opinion, if just the original road were there. That's I know that's not the issue before it, but it's in my mind an important factor to understand, at least to me. Putting in a second road by definition is going to cause additional disturbance.
Thank you, Mr. Loftman. So we go now to Mr. Chu Il Lee for his 5-minute rebuttal, and then we come back to the commission, the board for further discussion and or a motion and a vote. So Mr. Chu Il Lee.
Thank you, Madam Chairwoman. There's a lot to cover in a very short amount of time. First, Ms. Davidson, to your question, I didn't think we would need to address it because of what you had raised, but I think it's important to address it now, given the other statements that were made by this board, or some of the statements made by this board. There were statements by Mr. Kane, there were statements by Ms. Dennison, and statements by Mr. Ruthenberg, I apologize, about the quality of the lake and in the watershed. When you look at that, though, it's important to look at one of the exhibits that the Plan Commission put in there, and that is the settlement agreement between the parties. Again, keep in mind that that initial lawsuit began with the county filing a lawsuit against Mr. Huff and Mrs. Huff and the trust. It resulted in the county paying the Huffs $50,000 or agreeing to. It resulted in that statement on number 7 that prior to anything outside of agricultural uses, we'll come get the permits. And you know, Mr. Daley, I think that goes to one of the questions that you asked. It's in the agreement itself that we'll come and get all the necessary permits if it's not agricultural in nature. But if it's agricultural in nature, it doesn't apply. And so I disagree with Mr. Schilling's proposition, and I think that the county's own exhibits demonstrate that. When we talk about this road, Mr. Lofton, and the additional concern about erosion on there, I understand the thought process that if you're moving more dirt, it's going to add more erosion. But the issue here is the slope of the original road. We are talking about slopes in excess of 26%. There are affidavits in front of you. Again, this is for the consideration part on the variance itself, but there are affidavits in front of you as part of the evidence that talk about the manner in which that existing road, the old one, erodes at a much higher rate. The slope is over there by at a much higher elevation, and it is closer to the lake itself. When we look at this road in actuality preserves less erosion towards the watershed. And everybody who's looked at this property regarding the quality of the lake has agreed. Samantha Wekaiser from IDEM came out and did an evaluation out here and saw no erosion control issues whatsoever. Everybody who came out here has agreed that there's no damage to the lake, to the point in which the county agreed, if you look back at that agreed judgment, in number 8, that they would issue the statement that they have no evidence and they've seen nothing that shows that the Huffs have done anything to damage this lake. Yet that's what we've heard consistently through here. This is a use, and I disagree with Mr. Schilling. This is a use variance. It is 350 feet of a structure that is defined as a use in your own ordinances. I'm using your language to come up with this. It says that a structure is a use, or a structure qualifies as part of this, and a road is a structure. And so it is the ability of the Huffs to utilize that 350 feet for the residential purposes. Guess what? It cannot be utilized right now, that structure, for the residential purposes in this current area. That is why it is a use variance. It is not a design variance, because we do not have to come back to get any of the permits or any applications or any approvals if it's agricultural in nature, pursuant to the agreement of the parties that is in front of you as a record. Thank you.
Thank you, Mr. Chu Ili. And I'm going to just, because I see a few hands raised, Mr. Kane, when we actually discuss the design or use standards variance after we go through this procedural process, you'll have another opportunity to speak. But right now, the public comment period is over. So I just wanted to let you know that. And right now before us is first of all, the consideration of whether or not we are considering the request by the Huffs for this property as a use variance or a design standards variance. And so that is what is before us here on the Board of Zoning Appeals. And I turn back to my fellow panelists and the board to have further discussion and or a motion on whether or not we use this as see this as a design standards variance or use variance. Ms. Owens, I see your hand is raised.
Thank you, Madam Chair. Mr. Lee talked a lot about the settlement agreement, and my question to him would be, is that the typed or the handwritten one?
It is the one that the county has put in to evidence today, so the typed one.
All right, thank you. And you also noted that, I think, quote, there's less erosion to the watershed. Actually, the inside slope of that new driveway still flows toward riparian areas. So it still can be very damaging, which is the whole reason for the ordinances and the laws in the first place. And lastly, I'd like to ask Mr. Schilling about the what Mr. Lee said earlier about vacating Judge Harvey's order. What was that? What does that mean?
I'm not exactly sure about that. They have filed an appeal with the Indiana Court of Appeals of Judge Harvey's order, but no stay has been requested. So I'm just not sure what he was referring to.
Yeah, thank you, because the order was very clear that either you get the variance or you get rid of the road. So, okay, thank you.
Okay, back to members of the board. I'm sorry, Mr. Chu Ili, you'll have another opportunity to speak later on the next issue, which is whether or not the proper variance is granted. So are there further questions from members of the Board of Zoning Appeals? I see that Mr. Loftman has his hand raised, and then Mr. Daly.
The road that they used for a lot of logging worked for all the logging they did until they put in this new road. to me, saying that that is not sufficient for agricultural purposes is inconsistent with the fact that it did serve for agricultural purposes. It's hard. It's expensive. Some people, some contractors might say, well, I've had enough of this project, and you had to find somebody who you will probably have to pay more. But that road is sufficient. There's no need for putting in another road. It doesn't deprive them of any use. It doesn't meet the design standards. And I don't see any justification for saying, now that a lot of logging is done, conceivably not all of it, but a whole lot of logging is done, they suddenly need a new road. It was sufficient for all the logging that was done. It's sufficient for the logging that needs to be done. So that's how I view that road.
Thank you, Mr. Loftman. Mr. Daly?
Well, I had one comment, but I think I'm going to start with, I'm a little confused by my colleagues' just most recent comments. It seemed as if, Mr. Loftman, you're suggesting that your belief is that that road was not necessary, while there's experts in the field that had affidavits stating that it was necessary. So I'm not sure where that opinion seems to trump the evidence that was presented to us. But my other question is, I actually would like to hear from the attorney for the petitioner to address that last statement by Ms. Owens regarding the stay and Mr. Schilling's take on that.
So, Mr. Lee, if you would like to answer that question, and again, it's only on the issue of the stay that you referenced earlier in your presentation to us.
Yeah, and thank you, Madam Chairman, and Mr. Daly. It's not a matter of a stay, and I disagree with Mr. Schilling on that. The Judge Harvey issued her order in November. Within 30 days, if you want to appeal that, you've got to appeal it. We filed our appeal of Judge Harvey's order. The county filed a motion to dismiss that appeal. On January 13th, so after we applied for our variance, on January 13th, the appellate court came back and ruled against the county, denying their motion to dismiss, thereby accepting the appeal of Judge Harvey's order. Once the appellate court takes up an order on appeal, that order doesn't carry weight of law anymore. It's not a controlling standard because it is in the jurisdiction of the appellate court to make the determination on the facts that are in the record. And so that is what I was saying, that Exhibit 13 should be stricken from the record. Any comments regarding Exhibit 13 should be stricken from the record. And any consideration by this board of Exhibit 13 would be improper because you have an order that is up on appeal in front of the appellate court over the objection of the county.
Thank you, Mr. Lee. Mr. Schilling, and then I would like to just say that we are a properly impaneled Board of Zoning Appeals, and we have authorities that are given to us by our laws. And that although many of your arguments pertain to a court of law, and we may or may not know all of the aspects of your particular legal reviews, right now, we as a citizen board of zoning appeals are trying to determine whether or not your request should be considered as a use variance or as a design standards variance. And that's the item that we're considering right now. And Mr. Schilling, have I misconstrued anything?
No, I think that the issue before the board at this time is whether based on the new rules that you've adopted, this is a use variance or a design standards variance. And that is the issue at this time. There will be other evidence presented and discussed later by the petitioners that will help you in determining whether these variances should be granted or not. Right now, we're just trying to decide what type of variance it is.
Yes, and so I turn back to the Board of Zoning Appeals for any further consideration or a motion on whether or not this should be the variance being requested is to be considered a use variance or a design standards variance. And then we'll move on to the actual variance and consider it as either a use or a design standards variance. So it's a little complicated, but we're trying to be as diligent and open and considerate of Mr. Lee's position and the petitioner's position, and to hear from you and from the public about their concerns on these issues. So I turn back to the Board of Zoning Appeals, and I don't know if there's any further discussion or if there's a motion.
Well, I just want to say that Mr. Daly, I think these are difficult calls, but to me, while I respect the integrity of the people who are filing, saying that this had become impossible, it was possible for a long time. And there's nothing that tells me suddenly this became impossible. Certainly for agricultural use, for logging, there's nothing saying it couldn't be done. They're saying it's probably going to cost more. That's the implication of this. You're going to have to use bulldozers instead of trucks to haul the equipment. That's expensive, but they're saying it can be done. They're not saying it can't be done. That said, I conclude that this is a design standards variance and move that we determine that the petitioner seeks a design standard variance.
I second.
Okay, it's been moved and seconded to approach this variance VAR 22-53 as a design standards variance. A motion in favor is a motion to approve it as a design standards variance and thereby deny it as a use variance. Is this in relation to the Article 7 that was adopted as well in terms of the findings?
Yes.
So a vote in favor is a vote to approve this as a design standards variance.
Well,
Skip.
to determine it's a design standard variance, not to
Yes, thank you.
approve the design
Yes,
standard
thank you
variance.
for that. To determine this as a design standards variance. Skip Daly,
Present.
would you like to vote this as a design standard variance?
I'm voting present.
I think that's an abstention.
Okay.
Yeah.
No, there's a difference between an abstention and voting present. I vote present.
Okay,
It's based upon quorum
okay.
in majority.
Guy Loftman,
Yes.
Dee Owens,
Yes.
Pamela Davidson,
Yes,
Margaret Clemens.
Yes.
Okay, the motion is that this is to be considered a design standards variance by a vote of 4-0.
Okay. Thank you. Thank you very much, Director Nestor Jelen. So we are now in the process of considering this request as a design standards variance. And Assistant Director Tammy Behrman, would you please review for us some of the particular concerns that we should be considering as for this request as a design standards variance?
Sure. The findings under part 812-6C and the definition with being able to eliminate practical difficulties in the use of the property. So practical difficulties, staff, our findings are that the petitioners seek a variance from the slope regulations of the zoning ordinance, chapter 825. Most other parcels developed and undeveloped in the vicinity of the petition site exhibit significant areas of steeply sloped property. And we saw that in some of the exhibits here. The conditions on the petitioner's property do not create or constitute a relatively unique development problem in the Lake Monroe area. The existing private drive serving the petition site is a condition on the property that can be maintained and used for access and development, and thus is one that eliminates the alleged significant development limitations the petitioner seeks to address through their variance request. Findings under Part B of the practical difficulties definition that it precludes the development or use of the property in a manner or to an extent enjoyed by others conforming properties in the area. So the findings that the developed property in the petition site area are mostly improved with single-family dwellings and are mostly used for residential purposes. Staff has made site visits on more than one occasion and has traveled the existing private drive in cars and in pickup trucks without difficulty. The existing private drive has been used by large trucks to log and construct other portions of the existing drives, including hauling gravel. There are a number of building sites available to the petitioner's properties that can be accessed by the existing private drive. The existing private drive provides safe and reasonable access to the petitioner's properties for purposes of use and development, be it residential, recreational, agricultural, of the property. The requested variance is not necessary to enable the petitioners to develop or use their property in a manner or to the extent enjoyed by other conforming properties in the area. The requested variance for the new drive is not necessary to eliminate a significant development limitation. And under Part C of practical difficulties definition, that it cannot be reasonably addressed through the redesign or relocation of the development building structure, existing or proposed. The findings are the existing private drive on the site could have been maintained and used, negating the need for the new constructed private drive in question. Planning staff has received multiple partial site plans for the petitioner's property. The first partial plan received showed the existing private drive as the access to multiple residential dwellings and accessory structures. The building area of 8,750 square feet showed a possible home footprint that would not involve a new private drive to be constructed. A partial site plan subsequently received from the petitioners showed the proposed location of a two-story single-family dwelling with a 6,256 square foot footprint made larger by patios and swimming pools and detached and garages. And these are partially located over that existing private drive. And it showed the proposed addition of the new drive located on the slopes in excess of 12%. The location of the proposed new drive, now built, would make it possible to remove the portion of the existing drive that was in conflict with the proposed dwelling footprint and thereby increase the area available for development. The proposed dwelling could be scaled down or reconfigured and relocated on the property in a manner that does not conflict with the existing drive and in a manner that would render unnecessary the existence and use of the new drive. The location, size, and configuration of the proposed dwelling chosen by the petitioners from a number of development sites and options does not constitute a significant development limitation imposed by the zoning ordinance for which a variance from the zoning ordinance may be sought. The new drive does not resolve a significant development limitation that cannot be reasonably addressed through the redesign and relocation of the proposed dwellings. And then finally, Part D of the practical difficulties definition describes that it may not be reasonably overcome because of unique excessive costs of complying with the standard. So the finding is due to the presence of the existing drive The subsequent construction of the new drive was not necessary to overcome a uniquely excessive cost imposed by the zoning ordinance. The cost of constructing a new drive without variance approval was an unnecessary cost that could have been avoided had the petitioners first sought the permits required for its construction. That's it.
Okay, thank you, Assistant Director Behrman. We appreciate that, and I'm going to move directly now to Mr. Chu Il Lee. He has another 15 minutes to substantiate his case for the request for a design standards variance. And Mr. Lee, thank you for your patience, and we look forward to hearing from you.
Well, thank you, Madam Chairman. And again, I would reiterate, the Huffs did not come to this Board of Zoning Appeals seeking a design variance. They came to this Board of Zoning Appeals to seek a use variance. And after a passage of a new rule, replacing an entire section of your rules, the day of the meeting for the variance hearing itself, specifically saying and lining out that this Board of Zoning Appeals would have the authority to make the determination as to this site or the use or the design variance. This board made that determination that they're going to move forward with the design. And that is unfortunate because it is ignoring some of the evidence, again, that the Plan Commission has put in front of you. Within the Plan Commission's own evidence on exhibit number 12, which is the typed agreement, it specifically indicates that we will need to come to this board or to whatever authority that is granting the permits or the licenses or whatever to file at that time when it is not agricultural in nature. And I want to pause there a little bit because I don't believe that there's been any evidence that is put in here, especially with the commitment that the House made at the beginning of this to say, we'll use the old footprint that was put in back on August 30th of 2021 for the residential home. It wasn't to move that home around. It is for the agricultural purposes. The Huffs had applied to put in a barn, an agricultural barn that we sat in a meeting in April where the attorneys for the county said, a barn is a barn. It's a nice looking barn, but a barn, if you say it's a barn, it's a barn. Yet even on that barn, which is an agricultural building, we're left with a stopped application. Now we are in front of you because the affidavits, the evidence in front of you from the loggers and from the agricultural professionals say that they can't and will not use, not that it's just inconvenient, but they will not use the old road because of the dangerous conditions it provides. And they're not the only ones who talk about the dangerous conditions. In front of you are affidavits from a career firefighter and a sheriff of Monroe County, both of which spell specifically the safety concerns that are involved with the use of that old road. And those safety concerns not only are that the newly constructed 350 feet is the best way out there because it allowed for the sheriff's department to get out there quickly when searching for a lost person in Monroe County and utilizing drone technology to go search instead of trying to launch a boat. But if the old road is utilized, it is going to jeopardize the ability to get out to that property. Fire trucks may not be able to get up there. Police vehicles may not be able to get out there. And if that is a situation, then that would eliminate any possible usage of this property as a residential in my position. Who would want to be out in a residence that the fire department can't get to and the police can't get to if you need those emergency services? Those are the affidavits in front of you right now, and nothing speaks against that. The argument from the county has been consistently that the cost of going for the permit would be less than what we're seeking now in the development costs. But again, that ignores their own evidence in front of you and what we believe to be the law and what the county agreed to in the resolution of the last case. That only when it is non-agricultural in nature do we have to come to the county for the permitting. And now that ball's been moved, the rules have changed. And now we have to come out there for agricultural purposes. You know, it is a little bit shocking to me that we would be facing a decision such as what we have here today, that a determination would be made immediately prior to the presentation of a case, changing the rules and how the board will approach situations. And while you may say, did we have this power before? Well, you didn't have it in your rules and you found it necessary to adopt it that way today. The day the Huffs were coming to you. We believe that it qualifies for a design standard, but we don't believe that we need a design standard variance. And that is the underlying issue that we have right now, is the Huffs are not here to seek a design variance standard. We do not believe, and I think the law is going to be clear, that when it's agricultural in nature, we don't need a design variance to come to put in that. I think the county has already admitted to that in the agreement. And so if this board is making a determination on design variance, we'll leave it there. We don't need it. What we needed was a use variance for residential use of that old road. That's all I have. Thank you.
Thank you, Mr. Truili. I'd like to ask Mr. Schilling and Director Nestor Jelen whether or not it should be continued. From my perspective, the thing that we're considering tonight is a variance. And that is what the Huffs and Mr. Lee are requesting us to hear. And we've been pretty indulgent as far as the amount of time and the arguments made for a request for variance. Now, it was our determination as a board that this particular request falls more aptly under the design standards variance for request rather than a use variance. Now, I don't quite know how to say this, but arguing that the rules that one doesn't follow have changed seems a little bit ironic to me, but he's arguing that the rules have changed and that he was not prepared to argue for the design standards variance. I don't know if there's anything that would cause us to give a continuance for another month if he so wishes it, or what do you think is the best method of operating to be completely fair to the Huffs and for their future consideration of their contestation or request for a design standards variance?
Well, number one, you've already made that decision.
Yes.
And we've had the suggestion that the rules were changed because the Huffs were coming here with their petition. And to an extent, that's true, because this is the first time that I can recall this issue being raised in front of the Board of Zoning Appeals. So by statute, we're required to have rules on that issue of whether it's a use or a design. You adopted those tonight. And so you applied those tonight. And that's why the rules were changed tonight, because it's the first time the issue was raised. Whether they've had time to respond to the staff's belief that this is a design standards variance, that's up to you. But as you recall, that was the issue 1 month ago. And that's why it was continued to this meeting, because they wanted to make that pitch. And so they presented over 200 pages of materials. If you think that there's more materials that you might need, continue it if you like, that's fine. If you feel like you have enough evidence to make a decision, that's fine as well. There has been a statement about agreement number 7, and it's been portrayed as stating that the Huffs, that the county agreed that the Huffs are not required to get permits for agricultural uses. And I just want to state that that is not what the agreement says. It says that the Huffs agree that they will come forward for residential and non-agricultural permits. It doesn't say that the county excused them from the zoning ordinance requirements for agricultural uses. So I just wanted to make that clear. But as far as whether to continue, that's up to you.
Okay, so Mr. Chu Il Lee, you'll have an opportunity to speak after we hear from the board and from the public. You'll have a 5-minute rebuttal period. But I do see your hand raised, and I acknowledge that your hand is raised. But I turn now back to the board for further discussion before we take comments from the public. Is there anything that the members of the Board of Zoning Appeals would like further clarification on?
My hand's up here.
Oh, thank you, Ms. Owens.
Yes, ma'am. I know you can't see it. Thank you. I would like to know whose responsibility it was to keep up the old road, to do upkeep on the old road so that it is safe. Is that
Mr. Schilling,
responsibility of the owners, correct?
to make sure that the road serves the accessibility of the emergency vehicles for any dwellings that they plan to develop on the site.
Well, that is a private drive on private property, so the county is not involved in that, certainly.
Okay, thank you.
So it is the owner's responsibility to make that road safe, not the county's, and that is my point. Thank you. And then Mr. Schilling, you said that even if it's agricultural use, a site plan approval is required. It's not willy-nilly, do whatever you like. Is that correct?
Well, condition 22 in the land use table requires site plan approval for agricultural uses. But regardless of whether there is a permit requirement or any approval requirement, we have design standards that apply.
Correct. All right.
Okay,
And I want to say something clarifying about it. We're looking at the screen right now, the memorandum of agreement. This memorandum, as I recall from reading the file, was never signed. That's why Judge Harvey then interpreted what's the date of it, what's the effective provisions. She said permitting is required under that. Then we've heard from Mr. Lee that it's been appealed, gone to appeal, so it's sitting in limbo land. So it's hard when Mr. Lee, I will say, Mr. Lee, when you refer to the terms of the memorandum and to Judge Harvey's rulings, both as valid and invalid. I mean, it goes back and forth. It is true that the permitting, just as D. Owens just said, is still required with agricultural land. So the memorandum is either dispositive or it isn't. It was never signed. It seems to be up in the air what the final requirements are. We fall back on the county rules, which say permitting is required for this, that, and the other, and to protect our watershed and for other reasons. So I just find that back and forth. I can't decide when it's dispositive and when it is invalid. So it's a little incongruous for me.
May I have a point of order? I see a notice here that the Zoom has quit.
yeah, it's the Zoom, yeah, okay.
And I think we should be zooming.
It only took like 20 seconds
Okay,
before they got it back up.
We're
So,
back up. Great.
yeah.
I couldn't tell from that.
Yeah, oh,
Thank you.
yes, okay, so Mr. Loftman, did you have a question for staff before we turn to the public?
Well, what the Mr. Shuya Lee, I hope I'm doing that okay. It was very clear at the start of this meeting that we had adopted a new rule and that we were going to discuss it. And at that point, if he'd wanted to prepare for that discussion, he certainly could have asked us for a continuance, as he did last meeting when he felt perhaps surprised by the report and wanted a chance to review it. And personally, if he'd said, well, wait a minute, you can't adopt this rule and then apply it tonight without me having a chance to think about it, I would have been prone to grant a continuance, but he chose not to and engaged heartily in the discussion without objection to our considering it. So I don't think that is anything that makes me feel concerned. And he didn't address the substance of the design variance. He just
Right.
said it shouldn't be that. So I'm ready to hear the public. I think that's next.
Okay, and I can't see all of the panelists. I don't know if Mr. Daly is there and if he has his hand raised. So I will then, if there are members of the public who are here in person or on Zoom or on the telephone, either come to the podium or raise your hand. I see a certain number of hands raised already. I think I'll just go ahead and take them whether they're for or against, because I can't tell by a hand raise whether or not the people are speaking before or against the requested design standards variance. So I move first to Mr. Borgman. You have 3 minutes, and Mr. Borgman, if you would be so kind as to state your name, state your county of residence, raise your right hand, and do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do. And also, before I go, I am also with the petitioner as a representative. I don't know if that changes how this goes or not. I guess you'd have to ask Jackie.
Well, you have 3, I think he has 3 minutes, or does he? I don't understand.
Well, I think Mr. Lee did not give the rest of his time to Mr. Borgman, which I wasn't sure if that was the intent. So if we want to give Mr. Borgman 3 minutes to speak
Or,
in favor.
well, then 3 minutes in favor. Mr. Borgman, you have 3 minutes to speak in favor of this petition. Are you an attorney, sir?
No, I am. I work for Smith Design Group, the civil engineering firm,
Okay, and what county do you reside in?
Monroe County.
Okay, so you have be generous on your time, but please go ahead because the clock has already started to tick. So we look forward to hearing from you.
Okay, so I just want to briefly look at a couple of things when it comes to roads in Monroe County and how it relates to safety, not only for the public, but also for private citizens. Anytime you apply for an application in Monroe County, you need the highway department's approval. And it is 100% based on public safety. If you want to put in a house without a driveway, the driveway is based on public safety. If you want to put in apartment buildings and tie into a road, you have to do road improvements for public safety. There is no difference between Mr. Huff's private road and public safety and the roads that you do in commercial wise and other residential development. This county spends millions of dollars a year upgrading roads for public safety. Mr. Huff did the same thing on this road. I agree with you, Mr. Loftman. It is possible for vehicles to go up there and they were able to log on it, but that does not mean that it was safe, and that does not mean that it was the best option. There is no doubt in my mind that this new road is safe for the Huff family, for delivery drivers, for firemen, for EMS, and for police officers. And I think at the end of the day, there's been a lot of talk about this road, why it was here, why it's not. At the end of the day, public safety and the lives of the citizens of Monroe County needs to be the #1 deciding factor. Thank you.
Thank you, Mr. Borgman. Okay, and I think that Mr. Kane has his hand raised, or if, I'm sorry, we're coming back to you. And you're still sworn in from before. So you have 3 minutes. Yeah, he's muted. If you're calling on a telephone, you have to press *6. Sorry. Or if you're on Zoom's.
There we go.
Yeah,
Can you hear me now?
yes.
Yeah, they've used that road for years to do extensive development all the way down to the Chumley Peninsula. They've dragged in machinery there that is absolutely huge. I mean, it can barely negotiate the curves on the paved part of Shadyside Drive. I think it's a little disingenuous now to suddenly say that it's unsafe. I mean, thousands of big trucks have gone back and forth there in the last 4 or 5 years. But I also wanted to recommend, especially to the members of the board, to read the Lake Monroe Diagnostic and Feasibility Study written in 1997. All of these ordinances about this ecozone were kind of sprang from this study. It explains a lot about the lake and the sedimentation problem that we have. I think that would, there's talk about shifting the road this way and that way, but those ridges are so steep that if it doesn't go one way, it goes the other way. And it very quickly gets to the watershed. Doesn't take any time at all. They're so steep. I think that, I don't think we would be here tonight if the lake wasn't there. I don't think this petitioner would have any interest in this property. That it's because of the lake. It's a public amenity. It's paid for by the public. It's our only water source. The public has a huge stake in what is done on this property and all the property around the lake. The lake was not created to provide views for vacation homes. If you're going to change the variance this easily so that someone can, I don't buy the argument of a safer road personally. I think this is about building a bigger vacation house. But anyway, I think the same rule should apply to everyone that owns property around the lake. And if you don't, if you're not going to enforce the rules, we shouldn't have them. That's kind of how I feel about it. That's really what I wanted to say. And I thank you for your time.
Thank you, Mr. Kane, and thank you for showing up tonight. So we'll give Mr. Lee and Mr. Borgman combined 5 minutes to rebut things that were stated in the past.
Is there
So,
anybody
pardon me?
in person?
No,
Okay, I'm sorry.
no. Mr. Lee and Mr. Borgman, you have combined 5 minutes to rebut the public's concerns.
Thank you. And this is Mr. Lee, and I will go first, and I will be quick with this. I think Mr. Boardman did a phenomenal job of reiterating the issue here. This is a public safety issue when you look at this design. For Mr. Kane to say that he does not buy that, then he's throwing out the sworn affidavit from a lifetime, 15-year career firefighter and a sheriff deputy. You have the affidavits in front of you. You see what they say. This road is going to be utilized by the Huff family. Yes, but not only the Huff family, the individuals who are going to come make deliveries at those locations, the people who will be visiting the Huffs, the people who will be developing it and actually doing the construction. And, I've heard a couple times here now that, is it able to be used? One person brought up, whose job is it to maintain this? Well, in order to properly maintain the existing road, as I'll still call it, and put on, let's say, blacktop to make sure that we don't have any erosion going through. Once that's done, it is no longer a feasibility. It defies common sense to say we're going to take a bulldozer and pull trucks up. But that's how we're doing it now. That's the only way that can be utilized. And that's why the professionals are saying they're not utilizing it. You can't do that in the future if you maintain the road the way that you want to do it. A decision to not grant this variance is a decision essentially that is going against public safety. It is going against common sense and putting anybody who visits that property's life in danger. Ms. Davidson, you asked a question. I've been going back and forth. I think I've been very consistent when it comes to those orders. When it comes to Judge Harvey's order, I've consistently said that you should not consider that because the appellate court has taken it up. And I have consistently said and referred to the typed memorandum of agreement, which is Exhibit 12, and said, look at the words that are there. And for Mr. Schilling to say, oh, well, we didn't agree that the Huffs didn't have to come to us for stuff in agricultural is nonsensical. Again, it goes against common sense. If the agreement of the parties is that the Huffs have to come to get permits when it is residential or commercial, anything but non-agricultural, how in the world does it make any sense to say, well, they still have to come to us for that? It defies logic. I want to make it very clear for the record, because I think there are a couple of people said that we may want this. We are not asking for a continuance in this. We do not want a continuance. We want this board to move forward tonight in the manner that you are going to move forward. The Huffs have already been delayed for over 2.5 years by stopped applications for various reasons that haven't been applied to anybody else in this county. And so we want a decision. And at this time, I do want to save Mr. Borgen some time, so I will leave the remainder to him.
So just a couple quick things. You know, there's been several things referenced here about development that's taken place on the property. To my knowledge, there has been no development on the property. The only use of the property, to my knowledge, has been agricultural and logging. And secondly, to go back to the roads, these roads were started just like every other road in this county. They probably started with foot traffic and then horse and then wagon trails and eventually motorized vehicles. And just like every other road in this county, they need to be modified and upgraded for public safety. Thank you.
Thank you, Mr. Borgman, and thank you, Mr. Lee. Okay, the issue before us tonight is whether or not we should be granting a design standards variance. And in order to grant that, it is required that A, the approval, including any conditions or commitments deemed appropriate, will not be injurious to the public health, safety, and general welfare of the community. And there are sub-points underneath that. B, the approval, including any conditions or commitments deemed appropriate, would not affect the use and value of the area adjacent to the property, included in the variance in a substantially adverse manner. C, the approval, including any conditions or commitments deemed appropriate, is the minimum variance necessary to eliminate practical difficulties in the use of the property, which would otherwise result from a strict application of the terms of the zoning ordinance. So though they also have to demonstrate practical difficulties, and those practical difficulties would mean a significant development limitation that arises from conditions on the property that do not generally exist in the area. In other words, the property conditions create a relatively unique development problem. Or B, precludes the development or use of the property in a manner or to an extent enjoyed by other conforming properties in the area. Or C, cannot be reasonably addressed through the redesign or relocation of the development, building, structure, existing or proposed, and may not be reasonably overcome because of a uniquely excessive cost of complying with the standard. And I think I was erroneous. They have to satisfy all of those requirements, not just one of them. So I come back to the board and for further discussion, clarification, and or a motion.
You know, I'm just looking at the Huff's letter to the Board of Zoning Appeals. we're requesting relief from the 12% slope restriction to use an existing logging agricultural road for residential purposes. That they were asking that this road be used for residential purposes. If they're asking for it to be used for residential purposes, under the agreement, if it was binding or not binding, that then it's odd that they're saying this is for agricultural purposes when the Huffs, who are the petitioners, said it was for residential purposes. So that's my comment.
And right now, the variance that we're discussing has to do with the environmental constraints overlay in terms of area 1 design standards variance. So this also is tied to the environmental constraints overlay, which has stricter slopes, 12%. Slopes and above cannot be built upon because of its proximity and its possible impact to the water that our community relies upon. So that is just one clarification as far as what we're deliberating on and whether or not anyone would like to add anything. I see a hand raised by a panelist. That must be Dee.
Yes, ma'am, it's me. Thank you. All 5 of those are all what you just read that have to be met. I'm not hearing that. I did hear Mr. Lee say that this defies logic. And I think that being told by planning staff on the 9th of April of 2021, what was needed in order to make this road and defying that defies logic to me. If you know what to do and you have been told what to do and you don't do it and you go and do what you want anyway, that is not somebody that I trust when later on they say, well, we're going to do this and we're going to do that. It's been demonstrated that they will not, because they've already done this in open and plain defiance of what planning told them was necessary, and it could have actually been kind of a nothing deal. So I think defying logic goes both ways.
Thank you, Ms. Owens.
And I want to add that for Mr. Lee and Mr. Boardman, yes, I'm very concerned about the public safety aspects. That affidavit from the sheriff, the firefighters, all those individuals, those were very compelling to me. And the logging road, yes, it's been used that way for a long time, but that takes a lot of wear, abuse, and looking at that slope, I could just imagine how those tires wore the slope closer to the lake away. I have some fears that the higher slope of the existing road versus the lower slope farther away from the lake of the new road that makes more sense. I see those safety concerns. And, the standards of the design use variance says, is there public safety? Are there practical concerns? Are there economic concerns? Well, all the loggers said, gee, if we're going to do any more logging, which we all wonder about, but if they're going to do more logging, we're going to do it in a far more expensive way because we do not trust the road and we've been using it. So we did hear some testimony and saw those things. And I think those are compelling factors. And I want to point out to Mr. Lee and Mr. Boardman that, yes, we saw those and yes, we heard that.
Okay, is there any further discussion or a motion?
It's going to be our motion.
For BAR 22-53B, environmental constraints overlay area 1 for a design standards variance. Is there a motion to approve this?
I move to deny the design standard variance request in variance 22-53. There are alternate uses that can be made. It is not creating an unnecessary hardship.
Okay, thank you. And Is there anything further you need, Mr. Schilling, as far as helping us make this tighter, the motion, as far as avoiding further? I mean, have we made our justifications clear?
You've made the motion and we can prepare findings of fact. We can prepare written findings of fact to support your decision, whatever that decision
Okay.
is.
Is there a second then?
Yes, I'll second.
Okay, and Ms. Nestor Jelen, will you please call the roll?
Okay, and just to confirm, Guy, you mentioned unnecessary hardship, but since this is being evaluated as a design standards variance, did you by chance mean practical difficulties?
Yes.
Okay. Sorry, we had both flipped up on the screen, so I could see some confusion there. So this is a recommendation or move to deny the design standard variance to the Eco One Chapter 825 variance, which is VAR 22-53. So motion in favor is a vote to deny the variance. D. Owens,
Yes.
Pamela Davidson,
No.
Margaret Clemens,
Yes.
Skip Daly,
No.
Guy Loftman.
Yes.
Okay, the motion is to deny the variance by a vote of 3-2.
Okay. Thank you, everyone, for your patience and for your good listening and consideration and deliberation of the request. Okay, and I also want to thank Mr. Morrow for his patience and waiting for us tonight. The next three items on our agenda are concern VAR 22-5A, 55A, VAR 22-55B, and VAR 22-55C. And this is the Morrow minimum lot size variance to chapter 804, the Morrow buildable area 15% slope to chapter 804, and the Morrow environmental constraints overlay area 1 to chapter 825 concerning 3.72 plus or minus acre parcel in Salt Creek Township at 10,000 East Kent Road. And Ms. Crecelius, if you would please review this with us.
Absolutely. Thank you. Okay, so the property is out on the edge of the county in Salt Creek Township, section 11. So the property is zoned Forest Reserve, Eco Area 1 and Eco Area 2. The majority of the site is only in the Eco Area 1. So this is a site conditions map utilizing contours that are derived from 2012 slope data, LiDAR data. So again, this is an approximation of steep slopes. So this would be, we would be looking at slope restrictions of 12% for Eco Area 1 on this site and 15% buildable area for structures from Chapter 804. So because the petition site is zoned Forest Reserve, I'll start with the first variance, which is the minimum lot size. The Forest Reserve zone requires a minimum lot size of 5 acres. This property is currently 4.32 acres and is a single family residential use. For any kind of change to structures, if it did not meet the small allowances under our pre-existing non-conforming chapter of 803, it would need to would minimally require a minimum lot size variance from that zone. So upon submission of an electrical permit for a solar panel installation, planning staff discovered multiple unpermitted changes to structures on the site. To date, as-built permits have been submitted, and these 3 variances are the minimum required for any kind of improvement location permit issuance. So I'm going to go over just the changes on the site that we have found. Pre-2011 aerial imagery is rather grainy and is really quite hard to get any kind of grasp with the structures. So we have at least 4 dates here that we can kind of go through the changes on the site. So from 2011 and 2016, we can see that the hill behind the property that is sloped has seen some stabilization, which is a good change. would not necessarily require a permit. I'm just kind of illustrating. There's what you see in the aerial imagery in 2016, kind of a swath of white that's curved. That is kind of a rock wall kind of situation on the slope. So that just illustrate that. What we're looking at here in 2016 and 2011 is that the two residential accessory structures or sheds have increased in size without permits. From 2016 to 2019, we see that both sheds again increase in size. And then from 2019 to 2022, we see that the primary residential structure has also been increased. It has the footprint of the home, the roof line has changed. So we can see an expansion of a front porch on the north side and 2 additions on the south side. So because no permits were applied for, we have no documentation of what the slope on the site would have been before any kind of changes to the structures. This is an image from 2011. We can see that the property is sloped to on the far left side of the image beyond the pool, which would be to the south, going south on the property. We can see that hillside that became kind of a rock wall. We can see that there is kind of a hill from the pool going north to the house, and that there's the area where the home was expanded to the south, 2 additions, generally appears to be somewhat flat in 2011. This is again a pictometry photo, but this is from 2022. So we can kind of still see some of that same elements, but because there were no permits, we have no data verifying what kind of slope percentage was on ground. And if there was a violation of the 12% slope restriction and a 15% slope restriction. So I'm just going to go through a few site photos. So the site has been greatly improved. Here in the front yard is a garden and trellis structure. So towards just going back, so towards the front of the property, towards East Kent Road, there would be on the north side of the property, it does contain buildable area. So here the primary residence is on the right, and we can start to see some of the sheds that as you move south on the property. So there is a small firewood shed, which is not necessarily easily identified on the aerial imagery. The 2 sheds that we were really looking at are the shed that's on kind of the right of the photo and directly in the center. So this would be an area that is undetermined whether it was greatly graded or improved if the slope was disturbed here in this area. So the 2 roof lines of the primary house in blue, those are the 2 additions that were into kind of what originally was a parking area from what we can tell in 2011. On the left side of the image, we can see one of the sheds that have been expanded multiple times. It appears to currently, be still a personal residential use. So we can kind of begin to see the rock wall, and then this is looking south towards the back of the property as the slope continues to increase. So walking up the slope to look down, there is a kind of a steep slope to the right. We were able to verify with an older survey that the accessory structures do meet their side setback requirements of the zoning district. So just for clarification, the petitioner's letter did include some information about a side setback variance, but we were able to confirm that that was not needed. Okay. So here is one of the sheds that has been expanded. So ultimately, because there is a lack of information overall, and we are not able to know what that slope was at the time, because there were no building permits, we are recommending 2 different motions. We do recommend approval for the minimum lot size variance to Chapter 804, because we see that the property has been a residential use, is a legal lot of record, and is continuing to be used that way, and we would support that. But because of the standards of approval for the buildable area, 15% slope, which is VAR 2255B and 2255C, also from the Eco Area 1, 12% slope. We believe that this is a self-created hardship and therefore we recommend denial.
Thank you, Ms. Crecelius. Do members of the Board of Zoning Appeals have questions for staff? And I would like to also note that Mr. Daly is going to have to leave at about 8:05 p.m. Okay, so with that being said, if you have questions for staff.
My question is, as you're looking at the shed, the blue shed with the lattice work on the side. So even though that's not a permanent structure, that is like, there's not a foundation, there's not a poured concrete wall, floor, it looks like it's open to the elements, that still is within our regulations. Is that correct? Being not a permanent structure seemingly.
Yeah, so the requirements for an improvement location permit, which is our predecessor to issuing a building permit, it says that it must be if it's 120 square feet or permanent foundation. So it's over 120 square feet.
I see. So it's the size that
Yes.
propels it. Thank you so much.
Anybody else? I see Mr. Morrow. I assume that's you. Yes, and if you have 15 minutes, if you would kindly come to the podium. And if you have, you need to sign in and then I'll swear you in. And you'll have 15 minutes to go over with us, your case. And thanks for your patience tonight.
Oh, sure. This is hopefully going to be much more simple than the previous one, but very interesting. I've never done this before. So.
So, sir, would you please raise your right hand? And do you swear to tell the truth, the whole truth, and nothing but the truth?
Absolutely.
Yeah,
Yep.
and would you kindly state your name and state what county you live in?
Robert Morrow, and I'm in Monroe County,
Okay,
Maryland.
thank you. Well, you have 15 minutes to discuss with us, your case and your claims for your petition. So,
Okay. All I know is that those three sheds that you're talking about, the two, I guess, the top, they were existing sheds that I moved. So, one of them was right up against the house, the one that's wrapped up, not the one we're looking at here. I don't know if you can show that one, but so I moved that one up the hill into the flatter area, and the blue one that you're just looking at, all I did to that one was rotate it, but I did put what you're calling, I call it lean-tos on them, right? And there's the carport that was right up against the original house is what was moved up the hill to, I don't know if you have that one that shows the old sheds. Oh, and it'd be up there, be the upper left-hand corner. See the pool? I don't know if you can zoom in on that at all. But if you care. What I show, that's the one where I gave you guys. So number 2 that you're seeing there, that's right next to the pool, that's the one I moved down into the flat area by the garden. Okay. Number 1 was the aluminum carport thing, I guess. That got moved up to the flat area where number 2 is. And then I got a bunch of steel on that, was able to encase that. And I also put a lean-to on that that's been encased. So this is just what I've done. And number 3, that's just a regular 8x12 shed that just got rotated. Okay, and they do all have those lean-tos on them. So I'm just telling you what I did to it. So that's why I'm hoping to get a variance on these things. I don't know what the requirement is or what the reason, is it a watershed thing or is it I don't know what the requirement is. The what I call the shop, which is now in position number 2 that you see up there. There was something in your information that said it had to be 15 feet away from a slope. That one is, I went out and measured it. The closest one to the slope is it's like 15 feet, 4 inches
Mhm.
away from the slope. The smaller one, the blue, what you're calling the blue shed, that was only about 7 feet away, if you include
Mhm.
the lean-to things. So,
So would you
Yes.
be so kind as to answer his questions? Yes.
Absolutely. So the zoning ordinance was adopted in 1997. With it, the environmental constraints overlay, so that watershed protection for Lake Monroe was adopted with it as chapter 825. And it identified those areas of different tiers, eco area 1, 2, and 3, and put in place slope restrictions. Generally, if you're not familiar with a slope restriction like eco area or buildable area, planning department will generally inform you when you apply for a building permit, and we explain those kinds of issues. And we might recommend a route like a variance here preemptively. We also might help you identify where that, a structure could be placed, that it could meet those conditions. Those are things that we would normally work through when somebody applies for a building permit. So because no building permit was ever applied for, we've not necessarily ever had an opportunity to explain that there were slope restrictions on the property. Unless you had explicit experience with the zoning ordinance, you might not have been familiar with that.
yeah, I apologize. I did not apply for building permits on these things, but especially not the moving of the sheds. So,
Mhm.
Yes, so the Monroe County Building Department does require, as Director Jelen stated earlier, structures that are over 30 inches tall, greater than 120 square feet, or on a permanent foundation requires a building permit.
okay, 30 inches tall?
Yeah, so
Okay, no, that's fine.
elevated deck, that kind of
Oh, okay, all
situation.
right, okay, that's fine.
Yes, so.
That's fine. Oh, and yeah, and the deck on the front, you can see from the original one, that just got expanded and had a roof put on it. So.
Yes.
So I have a question for staff and for Mr. Morrow. Is there anything that can be done that wouldn't cause him too much hardship as far as moving those structures? Can you work with him to help him better site those sheds? Or?
There may be areas that are in compliance.
Uh-huh.
So, for example, the southern two additions to the primary house.
Yes.
Appears that it's probably been a flat or parking area for a while. But because we don't have that data and we don't have anything to compare it to before they were changed and moved around multiple times, we just can't say that there never was that kind of encroachment. Now, if these variances are denied, the structures would have to be either removed or relocated.
Okay. Relocating the extensions to the house is going to be impossible. Okay, those are concrete wall extensions on those. Obviously the blue thing, I could move the lean-to part of it off that. But the one that came from the aluminum carport, that's going to be extremely difficult to move. So,
For staff, getting back to the blue one, because that looked like the largest structure of all the sheds. If it were under the 126, if one side of that came off and the carport side stayed on, would then it work? Because of the size triggering that, or is it the slope concerns, or both of those that are your biggest concerns?
Yeah, so if a structure is under 120 square feet and not on a permanent foundation, it does not require an improvement location permit, but it still should be meeting design standards. So I think in this case, the two variances that he's requesting, the Eco 1 and the buildable area, are tricky because it applies to multiple structures. So by denying Eco 1, you're denying multiple structures of not meeting that Eco 1. So do consider that as you make your decision.
Okay, is there a way to divide up the Eco 1 like in is the house expansion in Eco 1?
The entire property all of the structures are located within Eco 1. A portion of the very southern part of the property as an eco two. So all of these, if these permits would have been applied for as required by the zoning ordinance, we would have required slope information, some kind of verification that they were not placed in 12% slope, greater than 12% slope.
So because I didn't have information beforehand is the issue?
The proper course of action would have been building permit applications submitted before any kind of construction work or ground disturbance.
I understand that, but the issue is that they're on a slope, right?
You would have had to
Yes.
come
An existing-
here before.
No, I understand that, but I'm trying to understand the specific mechanical part of it, is that it needed to be.
I think I
flat
understand.
ground.
So you could technically go out and get a surveyor and prove slopes right now, but the issue is that they could have been graded 10 years ago. It could have been 12% slope, where that work, we would not allow it to happen necessarily. Does that help?
Yeah, I mean, that didn't happen, but
And I think Ann, in our review of this building permit, correct me if I'm wrong, the main addition to the home is an issue because of the minimum lot size and the Eco One. But the three accessory structures are the minimum lot size, the Eco One, and the buildable area. So the 15% buildable area, I'm not sure if that applies to the home itself. Is that correct? I think it's just a 12% encroachment of the home. So by breaking them up, Eco One is the home and the accessory structures, but buildable area is only the accessory structures. Does that help?
Yes, so for example, if we were to take your recommendation and approve the minimum lot size variance, and if we were to approve in this case, the eco area variance of building on a 12% slope, then that would only allow him to keep his house. And if we deny the buildable area, that only pertains to the temporary structures. Is that right?
It would apply to the accessory structures, correct? I don't know that all of the structures were easily movable, but and if you want to show pictures of that again, or
Yeah.
The garage / work shed, so let me go back through the photos.
Yeah, I just am, I like to see
Yes.
that image with that.
Okay. So this structure, which is more towards the center of the property, is the largest.
Yes.
It is very much a permanent structure. I don't know whether it's a permanent foundation, but it is
No.
not a shed like the blue structure that has the additional lean-tos. The other structure was not something that was designed to ever be moved necessarily. This obviously is a manufactured shed that has been expanded, although I'm sure it would be difficult because it's manufactured. You can kind of see the foundation of the property of the structure.
yeah, there's the shop, the bigger shed, the shop, I call it. That has no foundation on it. It's an aluminum frame that has spikes that go into the ground where the aluminum sits down. And then I covered it. You can kind of see there the front is just wood and on the sides, it's just metal that's been put up over that. There's no permanent foundation there.
So that was a structure you moved, turned, placed there, and then put those pins in the ground
Yeah,
to hold it.
that's how it was to begin with.
Mhm.
I just moved it up there. And what I added to it was, you see that little walkway that I covered on the right-hand side of it. And then I put aluminum around the outside, trying to had a pile of it. So I used that. And then I just built the wood wall on that end that you're looking at right there. I kind of encased it so I could use it for a shop.
Was it open air before you encased it?
Yes, yes, it was.
Okay.
Sounds like you should make this motion
Well,
because you cannot make that.
I
motion.
cannot, but
Okay.
we also
All
have to
right.
take
Yes, of course.
comments from the public.
Of course.
Okay, thank you, sir.
Thank you.
If after the public, if they wish, to speak on this, you would have a 5-minute rebuttal.
Okay.
But are there members of the public who are online, on Zoom, who would like to speak either in favor or in opposition to these requests for variances? If so, please raise your virtual hand or press *9 on your telephone to be recognized. If, no, we'll I'll check 1 minute to see. Is there any member of the public who would like to speak in opposition to this, to these requests for variances? If so, please raise your virtual hand or press *9. So you can sit down. No one is here. Okay, so I come back to members of the Board of Zoning Appeals for further discussion. Is it just the 3 of us now?
And
D is still.
D is still here? Okay, so, and I don't, D has any questions?
No, I do not. Thank you.
So for further discussion and or a motion?
It's going to be a complicated motion.
Yeah, we should take them each one individually. The first one is VAR 22-55A, and that is a minimum lot size variance to chapter 804. Is there a motion on that?
I move that we approve that variance that you just described.
Okay, would you please call the vote?
Second.
Oh, yeah,
Okay.
thank you. Thank you, Mr. Lockman. I'm getting a little tired, I guess.
All right, it's been moved and seconded to approve VAR 22-55A, which is the Morrow minimum lot size variance to chapter 804. A vote in favor is a vote to approve just the minimum lot size variance. Margaret Clemens,
Yes,
Skip Daly is not present. Guy Loftman,
Yes.
D Owens,
Yes.
Pamela Davidson.
Yes.
Okay, so the first variance is approved 4-0.
okay. Well, we move on to VAR 22-55B, and this is the buildable area in the 15% slope restrictions to chapter 804. Is there a motion on this? This pertains primarily to the less permanent structures on the property.
Your turn.
The less permanent structures, I move that we deny variance 22-55B, the Morrow buildable area, 15% slow to chapter 804. And the paren to that is that it's the ancillary structures, not the house itself. Just as a matter of explanation to the board. Is there a second?
I'll second.
Okay, it's been moved and seconded to deny the Morrow buildable area 15% slope to chapter 804. A vote in favor is a vote to deny this specific variance, which is VAR 22-55B. Guy Loftman,
Yes.
D Owens,
Yes.
Pamela Davidson,
Yes.
Margaret Clemens.
Yes,
Okay, so the motion on the buildable area 15% slope was denied by a vote of 4-0.
May I ask just a point of order on that? With something like this where there's movement, change anticipated, does the staff work with the petitioner to come up with a good plan of action? How does that really work? Now that there's something to remedial to be done.
So do you want to answer that? Ann?
Yes, so we currently have the 3 building permits pending. So what we will do is we will say that the variance request for the 2 accessory structures, the location you proposed, which is existing, has been denied. You'd be required to relocate them or remove them, and it would be up to the petitioner to either give us an updated site plan or inform us how they're going to approach it.
So he is wise to give you a site plan before he does one thing, correct?
Yes,
Yes.
we will need updated information.
That's very good
Good
information.
information.
Okay, now the last variance that's being requested tonight is for VAR 22 55C. And this is Eco Area 1, building in the 12% slope, and this is a variance to chapter 825. And in order to approve this, we must find favorable findings for all three criteria, A, B, and C. Right, that the public is not harmed, that it's not significantly different than other properties in the area. And that, for example, this would cause a practical and very difficult thing for Mr. Morrow and an undue hardship. So we would have to find all three of those things. Is that correct?
That is correct.
Okay, so
So I make a motion that we approve variance 22 55C, the Morrow Environmental Constraints Overlay Area 1 to chapter 825. And my paren to the board is that those are the improvements to his home, correct? We got that right. Correct.
Second,
Okay, it's been moved and seconded to approve the Morrow Eco Area 1 variance to chapter 804, which is VAR 22 55C, based on the testimony and findings created by the board at tonight's meeting. A vote in favor is a vote to approve the Eco Area 1 variance. D. Owens?
Yes.
Okay. Pamela Davidson?
Yes.
Margaret Clemens?
yes.
Guy Loftman?
yes.
Okay, so that is approved by a 4-0 vote.
So Mr. Morrow, sorry, not everything is perfect, but we listened to you and we hope things are not as bad as you feared. And that, you'll work with staff to get everything else squared away. And thank you for coming tonight and thank you for your patience. Thank you. Was there anything else, staff? From Mr. Schilling? Okay.
Hey, sometimes you show on the screen here, recommended motion, something like that. But it doesn't sometimes show up in our packet, or if it does, sometimes I can't find it. I really appreciate having that. You think it is in the package? I'm not finding it.
It's there.
Yeah.
It is there on the first page, but if you need us to make it a little bit more obvious, I do sometimes scroll right past it. So
Oh, I know you're saying denial. Okay, I'm looking, let's just look at the top of this. Yeah, oh, I know that. What I'm saying is sometimes you have the motion written out that
I see. Okay.
that says because this doesn't meet, there's not undue hardship or stuff like that.
They put it here under recommended motion, like they recommended denial. Because it was a creative hardship.
Yes,
And we didn't listen to their rationale on the last item. We approved the first one, so
Well-
we approved that. Then we denied the second one. And then we overrode their denial, so that reasoning and rationale was ours.
right. And that's the reasoning section.
Yes.
So,
So.
but, okay.
The on
I'll-
goes into more detail on the HUP one, it was more detailed.
Yes. And what I'm saying is, when it comes time to make the motion, if the more elaborate one you think is appropriate is there, then I don't have to go back and mix and match the different. I want it easy. Spoon feed me.
On the PowerPoint slide, you mean, or on the reports?
Well, if it's in the packet.
Okay.
So when the time comes, if I'm going
Explain
to
the
stand by your now, if I'm going to go against it, I gotta make it up myself.
Yep.
But if I'm going to support it, it's just nice if we've got the motion you think would be appropriate before us. So because when I need to make a motion, then I had to go back and, find that it's got to meet A, B, and C, and I got to get A, B, and C, and they don't all fit on my screen. And if you have not just the action of approval or denial, but the mechanism, with drafted in there. Obviously, on some of these, you do draft them, and every time you do, it's nice for me. I'm not insisting, I'm just letting you know, it makes it easier for me to do what you all think we should do.
Sure. We'll try to elaborate
Well,
that. Thank you.
I just want to say thank you to everybody. I know we did take extra time on this this legal case, but I feel that it was the right thing to do.
It was worthy of taking extra time and consideration. Hey, Dee, that dream catcher behind you is pretty cool. Just saying. Are we adjourned?
Yes, I don't have any more reports.
Adjourned.
Okay,
Thank you.
thank
So
you.
moved.
So moved.
Great.
Thank you.
It's good. Oh, so. So cute, born November 18th, so cute. I go down with groceries and make things.